You're too ignorant to understand. 5 words, said on national television by a federal prosecutor to a black woman. In the United States Senate, 112,000 people watching live. C-SPAN cameras capturing every second. 14 senators bearing witness. He says it directly into the microphone. The word ignorant, deliberately chosen, slowly delivered. This moment will destroy him. But he doesn't know that yet. Rewind. 2 minutes earlier, the Senate Judiciary Committee chamber. A public hearing on federal prosecutor misconduct. Marble columns, mahogany benches, American flags behind the senators. At the witness table, Marcus Thornton, federal prosecutor, mid-40s, sharp suit, gold watch. He's testifying about his conviction record, his standards, his qualifications. In the public gallery, 3rd row, a woman sits quietly. Black woman, navy blue suit, natural hair pulled back in a low bun, pearl earrings. A leather portfolio rests on her lap. She's been taking notes for 20 minutes, writing in complete silence. Her pen never stops moving. Thornton talks about his cases, his success rate, how he maintains excellence in the justice system. The woman raises her hand. Every camera in the room turns. She stands, asks a question about one of his cases. Her voice is calm, professional. She uses precise legal terminology, references case numbers, appellate procedures. Thornton looks at her, studies her face. A smile forms. Not friendly. He asks if she's an attorney. She responds that she's asking about public record. He leans toward his microphone, tells her the case involves complex constitutional law, says it's probably beyond her understanding. A senator tries to interrupt. Thornton raises his hand, keeps talking. He says people without legal training shouldn't inject themselves into matters they don't comprehend. The room temperature drops. He continues, says maybe she should spend time learning before speaking. The woman doesn't react. Her face remains neutral. Her hand returns to her notebook. Thornton leans closer to the microphone, looks directly at her. You're too ignorant to understand. The silence is immediate, total, the kind that crushes oxygen from a room. The woman's pen pauses. 1 second, 2 seconds. Then it moves again. She's writing down what he just said. Every word. The live stream chat erupts. What did he just say? Is this real? Who is she? View count spikes. 112,000 becomes 153,000. A young staffer rushes to the committee chair, whispers urgently. The senator's expression changes. He leans into his microphone, speaks carefully. Mr. Thornton, pause. Do you know who you just addressed? Thornton shrugs, says something dismissive about concerned citizens. The woman closes her notebook, slowly. The sound echoes in the silent chamber. Her portfolio has something embossed on it. Gold lettering, an official seal. The camera zooms in. But before anyone can read it clearly, the senator speaks again. For the record, Mr. Thornton. Another pause. You may want to reconsider your words. Thornton's smile fades. Something in the senator's tone. The woman stands, straightens her suit jacket, picks up her portfolio, doesn't look at Thornton, doesn't need to. She walks toward the exit, heels clicking on marble. Every eye follows her. Every camera tracks her movement. The pen is still in her hand, the notebook tucked under her arm. She documented everything. Who she is, that comes later. What she'll do with those notes, that comes later. But one thing is already clear. Marcus Thornton just made the worst mistake of his career, and she has the evidence. 5 in the morning. The alarm doesn't sound. Evelyn wakes before it. Always does. A small apartment in Navy Yard. 2 bedrooms, modest rent. The second bedroom is an office. Floor-to-ceiling bookshelves. Legal texts, federal reporters, case law volumes. A desk faces the window. Washington Monument visible in the distance. She makes tea in the kitchen. Not coffee. Tea, chamomile with honey. Her mother's recipe. Her mother who cleaned government buildings in Alabama for 30 years. Who told her, if you're going to work in the law, work where it matters most. Evelyn carries the tea to her desk, sets it down carefully, opens a leather portfolio, an official seal embossed in gold. She doesn't look at the seal. She's carried this portfolio every working day for 3 years, but today it feels heavier. Not much, just enough to notice, more files than usual, more decisions waiting. Inside, documents requiring review, part of her job. She reads, takes notes, makes decisions that affect people's careers, people's lives. She doesn't take that lightly. This morning she reviews 3 files. All routine. All require her careful attention. She works through the first file methodically, makes notes in precise handwriting, marks her decision clearly, moves to the second file. Same careful process. No rushing. Her work doesn't allow for mistakes. Third file. She reads every page, cross-references information, verifies claims against records, makes her notes. This is what discipline looks like. Not dramatic, just thorough, every single time. Her tea has gone cold. She drinks it anyway. Before closing the files, she opens her notebook. Black leather, small, fits in her jacket pocket. Several pages have corner folds. She marked them last week. Cases she needs to revisit. Questions that need answers. She doesn't write which cases, just page numbers, references only she understands. Today might be the day some of those questions get asked, or maybe not. She'll know when the moment comes. At 6, her phone buzzes. A text from her husband. He's a public defender in Baltimore. Left early for a client meeting. The text says, heading to court. See you tonight. Love you. She texts back, good luck. Love you too. They met in law school, both believers in the system, both working to make it better. He from the defense side, she from the administrative side. Different roles, same goal. Justice that actually works. At 6:30, she closes her files, stands, stretches. She runs 3 mornings a week, not today. Today she has a hearing to attend. A public hearing on federal prosecutor accountability, part of her professional responsibilities. Observe, document, understand how the system functions. She walks to her closet, reaches for her navy blue suit, pauses, remembers something her predecessor told her. 3 years ago, her first week in this job, he was retiring after 20 years. He said, some nominations will test your judgment more than others. When that day comes, trust your preparation, trust your integrity. The decision will be clear. She didn't understand then. She does now. She's had those nominations. The ones that test everything. Maybe today will bring another. At 7, she dresses for the day. Navy blue suit, tailored but not expensive. White blouse, pearl earrings, a gift from her mother, her wedding band, her credentials badge on a lanyard. She picks it up, looks at it for a moment. A habit she's developed. Before important days, she touches the badge, reminds herself what it represents. Not power, responsibility. To the system, to the law, to the people who trust it to work. She puts the lanyard around her neck, tucks the badge under her blouse. She checks her reflection, hair pulled back in a low bun. Professional. Neat. Nothing flashy. She doesn't need to stand out. Her work speaks for itself. She picks up the portfolio. Heavier today. She notices it again. The notebook. Pages marked. Questions waiting. A pen. Not just any pen. A gift from her predecessor when she started this job. He said, do the work right. Every time. People are counting on you. She's carried that pen every day since. Used it to make decisions that matter. Today will be no different. At 7:15, she leaves her apartment. Takes the metro to Capitol Hill. Green Line to Navy Yard. Transfer to Orange. Gets off at Capitol South. She's made this commute hundreds of times. Knows every step. Every turn. But today feels different. Not nervous, just aware. The way she always feels before significant hearings. Ready, prepared, steady. She walks 3 blocks to the Senate building. It's cold. Early November in Washington. Leaves on the ground. Sky overcast. She enters the Russell Senate office building. Security checkpoint. She places the portfolio on the conveyor belt. The guard sees the official seal. Looks at her credentials. His expression changes. Professional respect. He nods. Says, good morning, ma'am. She nods back. Collects her portfolio. Notices the weight again. Heavier. She walks through marble hallways. Past portraits lining the walls. Past tourists taking photos. Past staffers carrying coffee and briefing books. She knows these halls well. She's been here many times. Different hearings. Different committees. Always in her professional capacity. Today she's observing. Part of her responsibility to understand how federal prosecutors operate, how they testify, how they present their records, how they answer difficult questions. At 8, she enters the Judiciary Committee chamber. Empty, except for a few staffers setting up microphones. She chooses a seat in the third row. Public gallery. Clear view of the witness table. Clear view of the senator's bench. She sits, opens her portfolio. The weight makes sense now. More files than she usually carries to hearings. She removes her notebook, opens to a page with a corner fold. One of the marked pages. She doesn't write anything new, just reviews what she already noted. Questions, observations, references. All in her handwriting, all waiting for the right moment. She uncaps her pen, writes the date at the top of a fresh page. November 7th, 2024, Senate Judiciary Committee. Federal Prosecutor Accountability Hearing. She's here to observe, to document, to understand. That's her job. Observe the system. Document what she sees. Use that knowledge in her work. The work that matters. The work people count on. At 8:20, other observers begin arriving. Law students, journalists, policy advocates. A man in an expensive suit enters, sits 2 rows behind her, checks his phone constantly. At 8:30, more people file in. The gallery fills slowly. Legal professionals, policy experts, students with notepads, everyone here for the same reason: to watch federal prosecutors defend their records, to see accountability in action. Evelyn watches them arrive, takes note of who's here, which organizations are represented, which reporters are covering this. It matters. Public attention creates pressure. Pressure creates honesty. Or it should. At 8:45, the senators begin arriving. Staff attorneys carry binders to the bench, thick documents, case files, testimony submissions, background reports. Evelyn recognizes the process. She's seen it many times. She respects the thoroughness. The Senate takes judicial nominations seriously, or most of them do. At 8:50, Marcus Thornton enters the chamber. Federal prosecutor, mid-40s, confident stride. He's the second witness scheduled today. She's read about his record. Impressive conviction rate, 94%, 200 cases. He's being considered for a federal judgeship. That's one reason she's here, to observe how he handles scrutiny, how he responds to questions about his methods, how he represents the values of the justice system. Thornton walks to the front of the chamber, doesn't sit yet, shakes hands with someone, a senator's aide. They laugh about something. He's comfortable here, at ease. He glances at the gallery briefly. His eyes pass over Evelyn. He doesn't register her. Why would he? She's just another observer in a room full of them, taking notes, watching, waiting. He takes a seat in the witness waiting area, checks his phone, adjusts his tie, goes over his notes. At 8:55, the chamber is nearly full. 300 people. Senators at the bench. Witnesses in the front row. Gallery packed. C-SPAN technicians check their equipment. Cameras positioned. Microphones tested. This hearing will be broadcast live. Thousands will watch. Maybe tens of thousands. Public accountability requires public witness. Evelyn approves. She closes her notebook for a moment, looks around the chamber, the marble columns, the portraits of past senators, the American flag behind the committee chair, the seal of the United States Senate. This is where democracy does its work. Messy sometimes, imperfect always, but necessary. She opens her notebook again. Her pen rests in her hand. At 8:58, the committee chair enters. Senator Davis, 20 years on this committee, known for fairness, known for toughness. He takes his seat at the center of the bench, arranges his papers, speaks briefly with the staff attorney beside him. Other senators settle into their chairs. The room quiets. Staff members take their positions. The court reporter prepares her machine. C-SPAN signals ready. The hearing is moments away. Evelyn touches her credentials badge through her blouse. The habit, the reminder. She's here for a reason, not just to observe, to understand, to document, to be ready for whatever her work requires. Her predecessor's words return to her. Trust your preparation. She's prepared. The files reviewed this morning, the marked pages in her notebook, the questions waiting to be asked, the 3 years of experience in her position. All of it has led to this moment. She doesn't know yet what will happen in this hearing. Doesn't know if today will be routine or significant. Doesn't know if the questions in her notebook will need to be asked. But she's ready. She's always ready. That's what the job requires. That's what the badge represents. That's what her mother taught her. That's what her predecessor trained her to do. Be prepared. Be thorough. Be ready. Senator Davis picks up his gavel. The room goes completely silent. 300 people waiting. Cameras recording. The moment arrives. Evelyn keeps her pen ready, her notebook open, her mind clear. Whatever happens next, she'll document it. Whatever questions need answers, she'll ask them. Whatever her responsibility requires, she'll fulfill it. The gavel falls. The hearing begins. Senator Davis speaks about accountability, about standards, about the responsibility prosecutors carry. Evelyn takes notes. She writes down every word. The first witness is called. A former federal prosecutor from Oregon. She testifies about training reforms, oversight mechanisms, the importance of transparency. It's solid testimony, thoughtful, measured. Evelyn notes the key points. But this isn't why she's here. At 9:20, the first witness finishes. Brief recess, 5 minutes. The chamber stirs slightly. People check phones, stretch. Evelyn stays seated, reviews her notebook, the marked pages, the questions waiting. At 9:25, the hearing resumes. The second witness is called. A criminal justice professor from Yale. He presents research on conviction rate disparities, statistical analysis, demographic patterns. The data is compelling, shows systemic issues in federal prosecution, bias, procedural shortcuts, pressure to win. Several senators take notes, others look uncomfortable. The professor's testimony lasts 15 minutes. Evelyn watches the senators' faces. Some care about this data. Others don't want to hear it. At 9:45, the second witness concludes. Another brief pause. The chamber resets. Then Senator Davis speaks. Calls the third witness. Marcus Thornton, federal prosecutor, District of Columbia. Thornton stands, walks to the witness table. He carries himself like someone who's never lost. Shoulders back, chin up, places his folder down, adjusts the microphone, settles into his chair. He's comfortable here. This is his arena. Senator Davis begins. Evelyn watches Thornton's face as the senator outlines his record. 206 cases, 94% conviction rate, federal judgeship nomination pending. Thornton nods at each statistic. Proud, no humility, no acknowledgement of the complexity, just pride in numbers. Davis asks him to describe his approach. Thornton leans forward. This is what he came to do. Talk about winning. He speaks about standards, about toughness, about not backing down. Says prosecutors today are too soft, too worried about criticism. Not him. He follows evidence, trusts the law, gets results. Evelyn writes results, not justice. She notices his word choices. Win. Aggressive. Don't back down. Get convictions. Never once. Serve justice. Never once. Protect the innocent. Never once. Ensure fairness. It's all about winning. Thornton continues. He talks about his cases, rattles off numbers, conviction after conviction, drug trafficking, assault, fraud, all victories. But he doesn't mention what happened after, the appeals, the reversals, the questions raised about his methods, just the wins. Evelyn notes this too. Selective memory, or selective honesty. Senator Martinez asks a question. It's about statistics, conviction rate disparities across racial demographics, the data the previous witness presented. Thornton's face tightens slightly. He says he doesn't see color in the courtroom, only evidence. The statistics reflect the cases he gets, not any bias. Martinez presses gently, asks if he's examined the pattern. Thornton's jaw sets. His tone sharpens. He asks if the senator is calling him racist. The room temperature drops. Martinez backs off, says she's just asking about data. Thornton doesn't apologize for the sharpness. He just returns to his talking points. Evidence. Convictions. Results. Evelyn underlines in her notebook. Defensive. Won't self-examine. At 10:05, Senator Davis redirects, asks about a specific case. Case 2019 Federal 4782. Evelyn's pen pauses. That number. She's been waiting for this. Thornton nods confidently. Says it was a major drug case. Complex, multiple defendants. 20-year sentence for the ringleader. One of his most significant victories. Davis asks what happened on appeal. Thornton hesitates, just for a second. Says there was an appeal, a procedural issue. Technical. Davis reads from the appellate decision. Constitutional violation. Exculpatory evidence withheld. Conviction overturned. Defendant released after 4 years. Thornton's face reddens. He calls it a judgment call, says the defendant was guilty, may have gotten out on a technicality, but guilty nonetheless. Evelyn writes, technicality ixilm constitutional rights. This man doesn't understand, or doesn't care. The law isn't a set of obstacles to work around. The law is the justice, due process, fair trials, constitutional protections. Those aren't technicalities. They're the foundation. Without them, conviction means nothing. At 10:15, the hearing opens for observer questions. Davis announces that legal professionals in attendance can ask questions. Public accountability requires public participation. Evelyn knows this moment is coming. She's prepared for it, but she waits. A white man in the second row stands. Mid-30s, expensive suit, legal academic. He asks about evidentiary standards. Thornton's face lights up. He smiles, calls him counselor. They have a substantive exchange, professional, collegial, respectful. Thornton takes his time, explains his reasoning, discusses legal theory, treats this man like an equal. The exchange lasts 3 minutes. Evelyn watches every second, notes the tone, the respect, the word counselor. She's seen this pattern before. She knows what's coming. The academic sits down. Thornton relaxes back in his chair, glances at his watch, thinks this is wrapping up. The live stream count hits 131,000. Evelyn opens her notebook, the marked page, the corner fold. The question she's carried for weeks. Her hand rises, steady, clear. Every camera turns. 300 people. All eyes on the woman in the third row. Senator Davis nods. Yes, ma'am, you have a question? Evelyn stands, picks up her notebook. Her voice cuts through the chamber. Clear, precise, deadly calm. Mr. Thornton, your written testimony references Case 2019, Federal 4782, as demonstrating prosecutorial effectiveness. Could you clarify the appellate outcome and whether the finding of misconduct was disclosed in your nomination materials? The question is a scalpel, sharp, specific, informed. This isn't curiosity, this is prosecution. The room feels it immediately. Senators sit up, staff attorneys freeze. The live stream chat accelerates. Thornton stares at her. He doesn't recognize her, doesn't know her name, doesn't understand the danger. What he sees, a black woman questioning him. What he doesn't see, the trap closing. His face arranges itself into a smile, the smile of a man who's never been challenged, never been told no, never been held accountable. Ma'am, are you an attorney? The question is an insult disguised as inquiry. Not, let me answer your question. But who are you to ask? The room shifts, uncomfortable. This isn't how you respond to a legal question. This is how you dismiss someone. Evelyn's face doesn't change. I'm asking about public record. Calm, factual, unmoved. Thornton's smile widens, gets uglier. I understand, but that case involves complex constitutional law, federal appellate procedure. I don't think you'd understand the nuances. There it is, the condescension laid bare. I don't think you'd understand. Not, let me explain, but you're not capable. He's telling a room full of legal professionals that this woman, this black woman, is too simple to grasp what he does. Senator Davis leans forward, tries to intervene. Mr. Thornton, the witness asked a specific. Thornton raises his hand, cuts off a United States senator. His voice rises, sharpens. Senator, with respect, this is exactly the problem. Uneducated individuals inserting themselves into legal proceedings they cannot comprehend. The word hangs in the air. Uneducated. He said it, on camera, into the microphone, to a black woman asking about his constitutional violations. Uneducated. The room goes rigid, not still. Rigid. The kind of tension that hurts. 300 people understanding exactly what just happened. A federal prosecutor, a man nominated for a lifetime judicial appointment, just called a woman in a Senate hearing uneducated. Not uninformed, not mistaken, uneducated, the word chosen deliberately. The insult coded but clear. Senator Martinez's hands grip her desk, knuckles white. Senator Davis's face has drained of color. A staffer in the back covers her mouth. The livestream count explodes. 131,000 becomes 158,000 in seconds. The chat moves too fast to read, but the words are clear enough. No. Did he just fire him? Who is she? Evelyn doesn't flinch. Her hand moves to her notebook, opens it, uncaps her pen, begins writing. Every word he said, documenting. Thornton sees her writing. It should stop him. It doesn't. He's too far gone now, too angry that she dared question him, too certain of his righteousness. Perhaps you should spend less time at public hearings and more time actually learning the law. The condescension has become cruelty. He's not just dismissing her question, he's mocking her existence in this room, telling her to go home, go study, go away, leave the real work to the qualified people, the educated people. People like him. Evelyn's pen keeps moving, steady, precise. She's not arguing, not defending, just recording. Her silence is more devastating than any response, because she knows something he doesn't, and she's writing it all down. Senator Davis tries again, his voice tight. Mr. Thornton, I strongly suggest… Thornton doesn't hear him, doesn't hear the warning. He's looking at Evelyn, at her calm face, at her steady hand, at her refusal to be intimidated, and it enrages him. She should be embarrassed, should be backing down, should be apologizing for wasting everyone's time. Instead, she's writing, calm as stone. His voice rises to something ugly. Ma'am, that case involves complexities of constitutional procedure that frankly require years of legal training to properly understand. Unless you have formal legal education, which I doubt, you're simply not equipped to engage with these issues. Which I doubt. He said it, out loud. The doubt that she's educated. The assumption based on looking at her, based on seeing her skin, hearing her voice, watching her dare to question him. The racism isn't subtle anymore. It's naked, raw, undeniable. The chamber is silent, but it's not the silence of attention. It's the silence of horror, of witnessing something that cannot be unsaid, cannot be undone. 300 legal professionals watching a federal prosecutor reveal himself. Evelyn raises her pen, not her hand, her pen, holds it up slightly between them. A small gesture, but it freezes him, because the pen is the record, the pen is the truth, the pen is what will remain when this moment is over. Her voice cuts through his silence, still calm, still measured, but now there's steel underneath. My question was whether the appellate court's finding of prosecutorial misconduct was disclosed in your judicial nomination materials, yes or no? Surgical, unavoidable. The question he's been dodging. Thornton's face reddens. That case was a procedural technicality. The evidence was clear. The defendant was guilty. The appellate decision was judicial activism, plain and simple. Constitutional rights. He's calling them technicality. A man released after 4 years of wrongful imprisonment. He's calling it activism. Evelyn doesn't raise her voice. Doesn't need to. The appellate court found you withheld exculpatory evidence. Constitutional violation. The defendant was released. You listed it as a victory. Facts, cold, irrefutable, delivered without emotion, which makes them more damning. Thornton's face goes from red to crimson. He's cornered, exposed, and he does what cornered men do. He attacks. I don't know who you think you are, but you are clearly… He pauses, searching for the word that will destroy her, the word that will put her in her place, the word that will end this. He finds it, leans into the microphone, says it slowly, deliberately. You're too ignorant to understand. The words detonate, not loudly, quietly, like a bomb that sucks the air from a room before the explosion. Too ignorant, not uninformed, not mistaken, ignorant. The word drips with contempt, with dismissal, with the certainty that she, this black woman who dared question him, is beneath him, beneath understanding, beneath respect, beneath consideration. The silence that follows is absolute, total, suffocating. No one moves, no one speaks, no one breathes. The kind of silence that exists after something irreversible happens, after a line is crossed that cannot be uncrossed, after words are spoken that cannot be unspoken. Evelyn's face remains perfectly still. No anger, no hurt, no reaction at all, just her hand moving across the page, writing, word after word after word. Every syllable he spoke, every insult, every dismissal. every revelation of who he truly is. She writes it all down. The pen moves steadily, precisely. The sound of it, pen on paper, is the only sound in the chamber, and it's deafening. Senator Martinez's face is stone, rage held by will alone. Senator Davis looks like he's been struck. A young staffer in the back is crying silently. Others are frozen, staring, unable to process what they just witnessed. The livestream count has exploded. 179,000, 192,000, 200,000, the numbers climbing by the second. The chat has become a waterfall of outrage. Fire him now. This is on camera. Who is she? Someone find out. Federal prosecutor just ended his career. But inside the chamber, there is only silence. And Evelyn's pen. Moving, steady, unstoppable. She fills one page, turns to the next, keeps writing. No one stops her. No one speaks. They're all watching her document the death of Marcus Thornton's career. In real time, in perfect silence, with a pen. Finally, she finishes, sets the pen down carefully, closes the notebook. The sound echoes. She looks up. Not at Thornton, at Senator Davis. Her face is still calm, but her eyes are clear, direct, unafraid. She doesn't say anything. Doesn't need to. The silence says it all. The record says it all. The 217,000 people watching say it all. Thornton sits at the witness table. His face has gone from crimson to gray. He's beginning to understand. Not fully, not yet, but enough to know. He just destroyed himself. On camera, in front of the Senate, in front of 200,000 witnesses, and the woman he insulted, the woman he called ignorant. She just wrote it all down. Every word. And she never once lost her composure. The silence continues. Crushing. Complete. The kind of silence that changes everything. The silence holds. No one speaks. No one moves. The chamber frozen in the aftermath of what just happened. 200,000 people watching. Waiting. Evelyn sits in the third row. Notebook closed in her lap. Pen resting on top. Hands folded. Perfectly still. The silence stretches. Becomes unbearable. Finally she moves. Closes her notebook deliberately. The sound echoes. She stands, slowly, picks up her portfolio. The weight is there, heavy. She tucks the notebook under her arm, turns toward the exit. Senator Davis finds his voice, looks at Thornton. His tone is cold. Mr. Thornton, you may want to reconsider your words. Not a suggestion, a warning. Thornton looks up, confused, slightly nervous, but still not understanding. Evelyn doesn't wait for his response. She walks. Her heels click on the marble floor. Each step deliberate, measured. Every eye in the chamber follows her. 300 people watching her leave. The cameras track her movement. She doesn't look back, doesn't need to. She reaches the doors, pushes through, gone. The moment she disappears, Davis speaks again. This hearing will take a 15-minute recess. The gavel falls. The chamber explodes. Whispers, phones, reporters rushing. But Evelyn is already gone. The marble corridor outside is chaos. Staffers on phones, reporters shouting questions at senators, voices overlapping. Did he actually? Career over. Who is she? Evelyn walks through it. People move around her. Don't see her. She finds a spot near tall windows, 30 feet from the chamber doors. Sunlight streams through the glass, cold November light. She stands there, sets her portfolio on the window ledge, opens it, removes her notebook, opens to the pages she filled during the hearing, reads what she wrote. Every word Thornton said, every insult, every dismissal. Her handwriting is steady, precise, no emotion in the letters, just documentation, evidence. She hears footsteps approaching, looks up. A man in his early 40s, junior senator from Colorado. She recognizes him from committee photos. Senator Williams. His face is uncomfortable, apologetic. He stops a few feet away. Ma'am, I'm Senator Williams. I wanted to, on behalf of the committee, I wanted to apologize for what just occurred in there. His voice is sincere, embarrassed. Evelyn's expression doesn't change. No apology needed, Senator. It's all on the record. Her tone is professional, calm, final. Williams shifts, uncertain. I understand. But what Mr. Thornton said was unacceptable. If you wish to file a formal complaint with the committee, we would— Evelyn shakes her head slightly. I don't need to file anything. I'm already exactly where I need to be. She says it simply, matter-of-factly, but the words carry weight. Williams pauses, looks at her more carefully, trying to understand what she means. Already where she needs to be? What does that mean? Is she a lawyer, a professor, someone from the Bar Association? Why does she seem so unconcerned? Not unbothered, but not panicked either. Not demanding action, just calm. He opens his mouth to ask, closes it, tries again. May I ask, what organization are you with? Evelyn closes her notebook, looks at him directly. That will be made clear when the hearing resumes, Senator. Not rude, not evasive, just stating fact. Williams nods slowly, still confused, still trying to understand, but sensing he won't get answers right now. Of course. Again, my apologies for what you experienced. He walks away, glancing back once, still puzzled. Evelyn turns back to the window, opens her notebook again. She's been in rooms like this before. Different chambers, different men. Same pattern. The assumption that she doesn't belong. The dismissal when she speaks with knowledge. The anger when she persists. She thinks of her mother, cleaning government buildings in Alabama for 30 years, coming home with stories about lawyers who didn't see her, judges who walked past like she was invisible. Her mother who said, "They can't see us, baby, so we have to see everything. Document everything, remember everything. Because one day, someone's going to ask, and we'll have the receipts." Evelyn has the receipts, in her precise handwriting, witnessed by 200,000 people. She turns to a fresh page in her notebook, writes clearly, recommendation, nomination withdrawn, not in anger, not in satisfaction, in clarity. Marcus Thornton demonstrated today that he lacks the temperament for judicial office. He cannot handle being questioned. He holds contempt for oversight. His biases, revealed in his case record, now confirmed in his conduct, disqualify him. She will write the memo, compile the evidence, make the recommendation. The Chief Justice will read it. Trust it. The Senate will not confirm him. She closes the notebook, sets it aside, looks out the window at the gray November sky. She's faced worse than Marcus Thornton. Different rooms, different men. Same pattern of dismissal, but this time is different. Before, she documented and reported, provided information to those with power to act. This time, she has authority, not borrowed, not delegated, her own. The authority to review, to recommend, to decide. This time, the system will work, not because she hopes it will, not because she trusts others to act, but because she is the system. Evelyn checks her watch, 10:38, 2 minutes until this hearing resumes. She closes her notebook, tucks it back in her portfolio, straightens her jacket, touches her credentials badge one final time, then walks back toward the chamber doors. The hallway parts for her, people stepping aside. Sensing something, she pushes through the doors, back into the chamber. The room is filling, senators returning, observers reclaiming seats, cameras repositioning. The live stream counter, 253,000 viewers. Thornton is already at the witness table. He looks smaller, less confident. His aide sits beside him now, whispering urgently. Evelyn returns to her seat. Third row, opens her notebook, pen ready. At exactly 10:40, Senator Davis enters. His face is set. The other senators follow, all wearing the same grim expression. The chamber settles. Davis takes his seat. The gavel falls. This hearing will resume. His voice is cold, hard. Before we continue, there are clarifications that must be made. For the record, he looks directly at the C-SPAN camera, then at Thornton. Mr. Thornton, 20 minutes ago, an observer asked you a legitimate question about your case record, about public testimony you submitted to this committee. In response, you questioned her credentials. You suggested she lacked education. You used the word ignorant. He pauses. You did this on camera, in a Senate hearing, before. He glances at a monitor. 253,000 witnesses. Thornton's face is pale. Senator, if I could— Davis raises his hand. You'll have your opportunity. But first, I think it's essential that we establish who you were addressing. He pauses, looks at the camera again, making sure this moment is captured. The woman Mr. Thornton addressed is not a concerned citizen. The words hang, sharp, clear, a beat of silence. Davis lets it breathe. Her name is Evelyn Morehouse. Another pause. Longer this time. The name means nothing to most people in the room, but the way Davis says it, the weight he gives it, signals something significant. Then he delivers the blow. She serves as the clerk of the United States Supreme Court. The chamber explodes, not loudly, but the shock is physical. Gasps, sharp intakes of breath. Oh my God, Supreme Court? She's what? The senators' faces tell the story. Some already knew. Martinez nods grimly. Williams looks vindicated. Others look stunned, but they all understand the magnitude. Thornton's face drains, completely white. His mouth opens, closes, opens again. No sound. His aide has gone pale too, staring at Evelyn like she's appeared from nowhere. The live stream explodes. The view count spikes in real time. 253,000, 271,000, 284,000. The chat becomes a waterfall. Supreme Court clerk. He called her ignorant. Career over. He's done. She reviews judges. Davis lets the chaos settle. Waits. The chamber gradually quiets. Then he speaks again. Not to Thornton. To the camera. To the record. To the 284,000 witnesses. Explaining. The clerk of the United States Supreme Court. Not a ceremonial title. Not an administrative assistant. The administrative head of the entire federal judiciary. Every federal judicial nomination in the country passes through that office. District courts, circuit courts, appellate courts, every single appointment reviewed by the clerk, assessed by the clerk. The clerk advises the Chief Justice on every nomination, manages all Supreme Court filings, oversees judicial conduct records, coordinates appointments across the entire federal system. Without the clerk's approval, nominations don't advance. Without the clerk's assessment, the Chief Justice doesn't move forward. Without the clerk's signature on the final recommendation, nominations die. And Marcus Thornton's nomination, his federal judgeship, the lifetime appointment he's been waiting 6 months for, it's sitting on Evelyn Morehouse's desk right now, waiting for her review, waiting for her assessment, waiting for her signature. The woman he called ignorant, the woman he dismissed, the woman he told to learn the law. She holds his professional future in her hands. Davis speaks again, his voice clinical now, detached. Ms. Morehouse, is it correct that Mr. Thornton's nomination is currently under review in your office? Evelyn stands, calm, professional. Yes, Senator, that's correct. And when were you planning to complete your assessment? I had scheduled final review for next week, Senator. Davis nods, looks at Thornton. Next week, Mr. Thornton? Ms. Morehouse will be reviewing your nomination next week. He pauses. Lets that sink in. In light of today's events, I'm certain her assessment will be thorough. The words are a death sentence, delivered calmly, officially, for the record. Thornton makes a sound, not a word, something between a gasp and a moan. Senator Martinez speaks. Her voice is quiet but cutting. Mr. Thornton, Ms. Morehouse asked you a direct question earlier about Case 2019 Federal 4782, about whether the appellate reversal was disclosed in your testimony. You never answered. You attacked her instead. Pause. I'll ask again. Was the appellate court's finding of prosecutorial misconduct disclosed in your written materials to this committee? Yes or no? The question is unavoidable now. Thornton looks at his notes, his aide, the table, anywhere but at the senators, or at Evelyn. Long silence. Finally, barely audible. No. Martinez nods. Thank you for that honesty, belated as it is. Davis speaks. Mr. Thornton, this committee will be requesting additional documentation regarding Case 2019 Federal 4782 and several other cases that have been flagged. You will be notified of next steps. He pauses. His voice drops. Cold. Final. Your testimony is concluded. You're dismissed. Not thank you for your time, not we appreciate your service. Just dismissed. Like a student sent from class. Thornton sits frozen. Can't move. Can't process. His aide touches his arm. Whispers. Finally, Thornton stands. Unsteady. His hands shake as he gathers his papers. Some fall. He bends to pick them up. His aide helps. They walk toward the exit. The chamber is silent, every eye watching, every camera following. Thornton's face is gray, sweat visible on his forehead, his hands still shaking. He passes Evelyn's row. For a moment he stops, looks at her, opens his mouth, maybe to apologize, maybe to explain. But Evelyn doesn't look up. She's writing in her notebook, documenting. Her pen moves steadily, precisely. He closes his mouth, keeps walking, through the doors. Gone. The chamber exhales. 297,000 people watching, all of them understanding what just happened. Davis looks at the remaining observers. This hearing is concluded. The gavel falls. Final. Absolute. Evelyn closes her notebook, places it in her portfolio, stands, picks up her things, walks toward the exit. Calm, unhurried, dignified. As she passes the senator's bench, Davis nods to her, a gesture of respect, apology, acknowledgement. She nods back, professional, brief, then she's gone, out into the marble hallway. The chaos has intensified, reporters everywhere, cameras, phones, everyone trying to get her statement. Ms. Morehouse, can you comment? Will you recommend? She walks through it all, says nothing. Her face calm, professional. A Capitol police officer appears, creates a path. She exits the building, into the cold November afternoon. Within an hour, the video is everywhere. Not just the live stream. Clipped, edited, shared. Prosecutor calls Supreme Court clerk ignorant. Federal nominee self-destructs on live TV. You're too ignorant to understand, Cha. And she was his judge. Twitter, Facebook, TikTok, Reddit. The clip goes viral. 5 million views by evening. 10 million by midnight. The hashtags trend nationwide. Hashtag ignorant prosecutor Anhart Evelyn Morehouse. Hashtag justice. On-camera news outlets pick it up. CNN runs it as breaking news. MSNBC does a full segment. Fox News covers it. Legal analysts weigh in. Constitutional law professors comment. Bar associations issue statements. The American Bar Association releases a statement, condemns Thornton's conduct, calls for review of his prosecutorial record. The National Association of Women Judges issues their own statement, notes the pattern of women being questioned in professional settings. His law school alma mater distances itself, issues a statement about not endorsing his views. The Department of Justice opens an internal review, not because of the insult, because of Case 2019 Federal 4782, the constitutional violation he dismissed as a technicality. The pattern is now public, undeniable, documented. 2 weeks later, Evelyn sits in her office, not in the Capitol, in the Supreme Court building, marble and quiet, the weight of history in every corridor. Her desk faces a tall window, view of the Capitol in the distance, the same building where Thornton destroyed himself. On her desk, a thick folder. Thornton, Marcus, Federal District Court nomination. She's been working on it for 3 days, methodically, thoroughly, the way she does everything. This isn't about revenge. It's never about revenge. It's about fitness for office, about whether this person should have lifetime power, about whether the system works. She opens the file, starts at the beginning. His law school record, strong, his early career, promising, federal prosecutor for 12 years, 206 cases, 194 convictions, 94% conviction rate. Impressive on paper, but she doesn't stop at the paper. She looks deeper. Cross-references with appellate records, searches federal databases, reviews complaints filed with the DOJ, reads transcripts. The pattern emerges slowly, then undeniably. 14 cases involving black defendants, all convicted, all with post-trial questions raised. 8 cases with procedural concerns, defense attorneys citing irregularities, evidence disclosure issues, witness credibility questions. 3 cases currently under appeal, allegations of prosecutorial misconduct, and Case 2019 Federal 4782, the one she asked about, the one he listed as a victory. She reads the appellate decision again, page by page. The court's language is clear, unambiguous. The prosecutor withheld exculpatory evidence that would have cast doubt on the defendant's guilt. This conduct violates the defendant's constitutional right to a fair trial. The conviction is hereby vacated. The defendant served 4 years, 4 years for a conviction the appellate court found constitutionally invalid. Thornton never mentioned this in his nomination materials, listed the case as a win, omitted the reversal, omitted the finding of misconduct. That's not an oversight, that's dishonesty. She makes notes in the margins. Precise, factual, no emotion, just documentation. She reviews his Senate hearing testimony, reads the transcript, his dismissal of constitutional protections, his calling them technicalities, his refusal to examine racial disparities in his conviction record, his defensiveness when questioned. Then she reaches November 7th, the hearing she attended. She doesn't need the transcript. She was there. She has her own notes. But she reviews the official record anyway, reads his words back to herself. Uneducated individuals. You're too ignorant to understand. She writes in her memo, nominee demonstrated inability to respond professionally to legitimate oversight questions. When challenged on case record discrepancies, nominee resorted to personal attacks rather than substantive answers. This behavior suggests unsuitability for judicial temperament required in lifetime appointment, not emotional, not personal, clinical, professional, systematic. She works for 6 hours straight. No breaks, just reading, cross-referencing, documenting, building the case, not against Thornton personally, against his nomination, against the idea that this record merits a lifetime judicial appointment. By evening, her memo is complete. 12 pages, single-spaced, footnoted. Every claim supported by evidence, every concern documented, every pattern proven. She reads it once more, checking for errors, for bias, for anything that isn't pure fact. There's nothing. Just truth. Documented. Undeniable. She prints 2 copies, one for her file, one for the Chief Justice. Signs her name at the bottom. Evelyn Morehouse Clerk, Supreme Court of the United States. The signature is steady, clear, final. She places the memo in an envelope, seals it, addresses it to the Chief Justice. The work is done. She picks up the envelope, walks down the marble hallway. The Supreme Court building is quiet at this hour. Past portraits of former Chief Justices, past the Great Seal embedded in the floor, the weight of history in every corridor. She reaches the Chief Justice's chambers. His assistant looks up from her desk, recognizes Evelyn immediately. Evelyn places the envelope on the desk. For the Chief Justice, Thornton nomination review. The assistant takes it carefully, respectfully. I'll make sure he gets this first thing in the morning, Ms. Morehouse. Evelyn nods. Thank you. She turns, walks back to her office. The memo is delivered. The process has begun. Her work, the documentation, the analysis, the recommendation, is complete. What happens next is out of her hands. The system will decide. The next morning, the Chief Justice reads her memo. All 12 pages, twice. His face is grave. He's known Evelyn for 3 years, trusts her judgment completely. She's never recommended rejection without cause, and this memo is airtight, evidence-based, thorough, undeniable. He picks up his phone, calls Senator Davis directly. Senator, we need to discuss the Thornton nomination. By noon, a sealed copy of Evelyn's memo arrives at the Senate Judiciary Committee. Davis reads it with Martinez and Williams, the 3 of them in a closed session. When they emerge, their decision is made. Davis calls a press conference that afternoon. After reviewing additional documentation and conducting further inquiry into Mr. Thornton's prosecutorial record, the Senate Judiciary Committee has determined that his nomination will not move forward. Mr. Thornton has been informed that he should withdraw his nomination. Pause. He has agreed to do so. The questions come immediately, reporters shouting. Davis raises his hand. The committee found significant discrepancies between Mr. Thornton's written testimony and the appellate record. Additionally, concerns were raised about a pattern of procedural irregularities in his cases. We take our constitutional duty to advise and consent very seriously. This nomination does not meet our standards. He doesn't mention the Senate hearing incident, doesn't need to. Everyone already knows. The video has 23 million views now. By evening, Thornton releases a statement. Brief, defensive. I have withdrawn my nomination for personal reasons. I remain proud of my record as a prosecutor and will continue to serve the Department of Justice. No apology, no acknowledgement, no accountability. But it doesn't matter. The damage is done. The Department of Justice announces its internal review 2 days later. They've been examining his case files, cross-referencing with the patterns Evelyn documented. Within 3 weeks, they release preliminary findings. 8 cases show evidence disclosure issues. 5 cases have witness credibility problems that weren't properly investigated. 3 cases are immediately flagged for appellate review. Defense attorneys across the district file motions, requesting case reviews, citing the DOJ findings, arguing their clients deserve new examination. The appellate courts begin reviewing. 1 case overturned in February, another in March, a third in April. 3 people freed. Years of their lives taken by convictions that couldn't withstand scrutiny. The Bar Association schedules a formal disciplinary hearing for June to examine whether Thornton's conduct violates professional ethics standards. The American Bar Association's model rules, specifically Rule 3.8, Special Responsibilities of a Prosecutor, the duty to disclose exculpatory evidence, the obligation to ensure justice, not just convictions. Thornton doesn't attend the hearing. His lawyer argues he's done nothing wrong, that aggressive prosecution isn't misconduct, that conviction rates speak for themselves. The panel doesn't agree. They issue a formal reprimand, cite him for failing to uphold prosecutorial standards, note the pattern of evidence disclosure failures, recommend he complete additional ethics training. At the Department of Justice, quiet changes happen. Thornton is reassigned, no longer handles trials, no longer appears in court. He's moved to legal research, a desk job, reviewing briefs, drafting memos, the kind of work that doesn't require facing judges or juries, or defense attorneys who might ask difficult questions. His Rising Star in Criminal Justice Award from the Bar Association, quietly rescinded, no announcement, no press release, just removed from the website. His profile page updated. The award section, blank. 6 months after the Senate hearing, the Judiciary Committee holds a follow-up session. Topic: Prosecutorial Accountability and Reform. The chamber is packed. Evelyn is scheduled to testify. This time, everyone knows who she is. Senator Davis introduces her. Ms. Evelyn Morehouse, Clerk of the United States Supreme Court. Ms. Morehouse has served in this critical role for 3 years. She brings institutional knowledge and a commitment to the integrity of our federal judiciary. We're honored to have her perspective today. Applause, respectful, warm. Evelyn takes her seat at the witness table, the same table where Thornton sat 6 months ago. The cameras are rolling, live stream active, but the tone is completely different. Davis begins. Ms. Morehouse, thank you for being here. Your office reviews federal judicial nominations. Can you speak to what you look for in candidates? Evelyn's voice is steady, professional. We look for integrity, competence, temperament, a commitment to justice that extends beyond win-loss records. Judges must be able to hear challenges to their reasoning without defensiveness. They must prioritize constitutional rights over expediency, and they must demonstrate through their record and conduct that they understand the weight of lifetime appointment. Martinez asks about systemic issues. In your review process, do you see patterns? Things that concern you about how prosecutors approach their work? Evelyn nods. Yes, Senator. There is sometimes an overemphasis on conviction rates as the primary measure of success. This can create incentives that conflict with the pursuit of justice. Prosecutors have a unique ethical obligation. They're not just advocates. They're ministers of justice. That means sometimes the right thing to do is to dismiss a case, to disclose evidence that helps the defense, to acknowledge when mistakes were made. She pauses. When that understanding is absent, the system fails. Williams asks about the review process itself, about checks and balances. Evelyn explains the layers. Her office's preliminary review, the Chief Justice's assessment, the Senate's constitutional role, the Bar Association's oversight, the appellate court's scrutiny. The system works when every layer takes its responsibility seriously, when nominations are examined thoroughly, when patterns are identified and addressed, when accountability exists at every level. Davis has one final question. Ms. Morehouse, 6 months ago, you attended a hearing in this room. An incident occurred that many have seen. Without discussing that specific case, what lessons should we draw about how we treat witnesses, how we respond to oversight, how we conduct ourselves in positions of public trust? Evelyn takes a moment, considers, then speaks. Public service requires humility. It requires the ability to be questioned without feeling attacked. It requires understanding that credentials and authority come with responsibility, not immunity from accountability. She looks directly at the camera, at the hundreds of thousands watching. When someone asks a legitimate question, the appropriate response is to answer it, not to question their right to ask, not to dismiss their capacity to understand. The moment we stop being willing to answer questions is the moment we've lost sight of why we serve. Silence, not uncomfortable, respectful, the kind that follows truth spoken plainly. Davis nods. Thank you, Ms. Morehouse. Your service to this country and your commitment to the integrity of our judicial system is deeply appreciated. The hearing continues for 2 more hours. Other witnesses, other perspectives. But Evelyn's testimony is what goes viral, not the dramatic kind, the quiet kind, clips shared by law professors, by judges, by young lawyers, by people who understand what she said and why it matters. The contrast with 6 months ago is stark. Side-by-side videos appear online. Thornton, dismissive, defensive, arrogant. Evelyn, composed, substantive, principled. The same room, the same camera angles, 2 completely different examples of how to handle oversight. She never mentions his name. Doesn't need to. The contrast speaks for itself. By evening, her testimony has 3 million views. Not because it's dramatic, because it's true, because it's what public service should sound like, and because everyone remembers what happened the last time she sat in that chamber, when a prosecutor called her ignorant, when he revealed himself, when the system slowly, imperfectly, but ultimately worked, because she was exactly where she needed to be. In the system, of the system. The system itself. 6 months after her Senate testimony, Georgetown Law School. A Wednesday evening in late spring. The auditorium is packed. 300 law students, first years, second years, third years, some sitting in the aisles, others standing in the back, all here for the same reason. The speaker, Evelyn Morehouse. The dean steps to the podium. It's my honor to introduce tonight's speaker. Evelyn Morehouse has served as clerk of the United States Supreme Court for 3 years. In that role, she oversees the administration of our nation's highest court and conducts critical reviews of federal judicial nominations. She is a guardian of judicial integrity and a model of public service. Pause. Please join me in welcoming Ms. Morehouse. The auditorium rises. Applause fills the room, not polite, genuine, warm. The students know who she is. They've seen the videos, read the articles, studied the case in their legal ethics classes. Evelyn walks to the podium. Navy suit, pearl earrings, calm expression. She waits for the applause to settle, then speaks. Her voice is steady, clear. The same voice that asked a question in a Senate hearing. The same voice that refused to be intimidated. Thank you. It's an honor to be here. When I was sitting where you are, I wondered what kind of lawyer I wanted to be. What kind of public servant, what kind of person? She looks out at the diverse faces. Black students, Latino students, Asian students, white students, all watching, all listening. I learned something important early. The law is not a weapon. It's a shield for the powerless. It's a tool for accountability. It's a promise that justice is possible. Pause. But that promise only works if we keep it. She talks for 30 minutes. Not about Thornton, never mentions his name. Talks about responsibility, about integrity, about what it means to serve justice rather than ambition. Your credentials don't define your character. Your actions do. You can graduate from the best schools, clerk for the best judges, work at the best firms, and still fail the fundamental test, which is, will you do the right thing when it's hard, when it's costly, when no one is watching? The students are completely still, listening. Documentation isn't revenge, it's accountability. When you see something wrong, you have a choice. You can ignore it, you can complain about it privately, or you can document it, build the evidence, create the record, make it impossible to ignore. She talks about her mother, the woman who cleaned government buildings, who told her, document everything. She understood something essential. Power protects itself. Systems defend themselves. The only way truth survives is if someone writes it down, if someone keeps the receipts. She talks about humility, about being willing to be questioned. The moment you stop answering questions is the moment you've lost sight of why you serve. Public service requires humility. It requires understanding that your authority comes with accountability, that your credentials don't make you immune to oversight. The students nod, some taking notes, others just absorbing. After her prepared remarks, the dean opens for questions. Hands shoot up immediately. A young woman in the third row. Black. First year. Nervous but determined. Ms. Morehouse, everyone here knows about the Senate incident, about what happened to you. Can you talk about how you handled that moment? How you stayed so calm? The auditorium goes quiet, waiting. Evelyn smiles slightly. I was doing my job. I attended a hearing as part of my professional responsibility. I asked a legitimate question about public record. What happened after that wasn't about me personally. It was about whether the system could work. Pause. And it did. Not perfectly, not immediately, but it worked. Because there were senators who took their oversight role seriously. Because there were colleagues who demanded accountability. Because there were 200,000 people watching who understood what they were seeing. She looks directly at the student who asked. The system worked because enough people believed it should. That's the lesson. Not that I stayed calm, but that the system, imperfect as it is, can still deliver accountability when people insist on it. Another student asks about fear, whether she was afraid. Evelyn considers. Not in that moment. I was prepared. I had done the work. I knew the facts. Fear comes from uncertainty, from not knowing if you're right. But I knew what the appellate record said. I knew what he'd omitted from his testimony. I wasn't afraid of asking the question. I was ready to ask it. The questions continue for 20 minutes, thoughtful, engaged. These students understand. They're inheriting a system. They want to know how to make it work, how to be the kind of lawyers who serve justice. Evelyn answers each question with the same care, the same precision, the same commitment to truth. After the event, the dean walks Evelyn to her car. You know, 3 law schools have added your case to their legal ethics curriculum, including ours. We use it to teach professional responsibility, prosecutorial ethics, the importance of documentation. Evelyn nods. I'm glad it's useful. More than useful. Essential. Students need to see that the system can work, that accountability is possible. You gave them proof. On the drive back to Washington, Evelyn thinks about the semester. The Senate passed new legislation in March, the Federal Prosecutor Accountability and Oversight Act. No one calls it that officially. Everyone calls it the Morehouse Standards. The law requires external review of conviction patterns, flags cases with procedural irregularities, mandates bias training for federal prosecutors, creates reporting mechanisms for defense attorneys to challenge misconduct. Thornton's name isn't in the bill, but everyone knows. Everyone understands why it exists. The pattern he represented, the accountability that was missing, the reform that became necessary. Evelyn returns to her office, the Supreme Court building, marble and history and quiet dignity. She sets her portfolio on her desk, the same leather portfolio she carried to the Senate hearing, the Supreme Court seal in gold. Her pen, the one her predecessor gave her, rests in its holder. On her desk, a framed photo, her with the Chief Justice at her swearing-in ceremony. 3 years ago, a reminder of the responsibility she carries. The window faces west, view of the Capitol in the distance. The same building where Marcus Thornton destroyed his career, where she asked a question, where the system worked. Sunlight streams through the window. Golden, warm, late afternoon light. She opens her notebook, the same notebook she's carried for 3 years, turns to a fresh page, blank, clean, ready. On her desk, 3 new nomination files, waiting for review, waiting for her careful attention, waiting for the work to continue. She picks up her pen, begins reading. Another case, another assessment, another opportunity to serve justice. The work never ends. But that's exactly as it should be, because justice isn't a destination, it's a practice, a commitment, a choice made every day, to document, to question, to hold the line. She writes the date at the top of the page, her handwriting steady, precise, ready for whatever comes next, because she is exactly where she needs to be, where her mother dreamed she could be, where her predecessor trained her to be. In the system, of the system, serving the system, making it work, one case at a time, one question at a time, one truth at a time. The pen moves across the page, the work continues.